Good morning. Welcome to the Bell and Pollock Legal Show. I'm Gary Bell along with Brad Pollock. Our law firm is Bell and Pollock. We are injury attorneys. We are here to educate you, to give you information, to teach you, and try to give you the information to put you on a level playing field with the insurance company who at all times tries to beat your claim, beat you as an injured victim, take you down, reduce your claim, mitigate your damages, not pay you, not even offer you sometimes the amount of your medical bills in resolution or offer of settlement in a case. And the information we give you is critical. Each week we try to cover a different injury subject for you so that you'll know and you'll have the information. And information, let's face it, is empowering. You can go to our website anytime, which is championsofthepeople.com. It's an information-loaded website. And by the way, it has all of our podcasts there. It has our video podcasts, our audio podcasts. It has all of our shows, including this show will be posted in due course. And so you can listen to any of the shows. We have blogs there. We have instructional series. And very importantly, on our website, championsofthepeople.com, we've got a button that you can hit, and it tells you it's an entire instructional series on what you need to know, what you need to do on your very first phone call with the insurance adjuster after you've been injured. Most people don't know that. I would say 99 plus people don't know that. And so you need to understand what their game is about. You need your own legal game plan, which we have for you. But they also have their own legal game plan, the insurance adjusters. They're trained. It's not just a haphazard call. It's just not planned. It is planned very well. It's strategically placed to you. They ask you the questions, and you better know what to do, what your rights are, what you can do, and what you can't do. All right, so we cover a different injury subject each week. This week we're talking about bad faith insurance practices. What does that mean? You know, bad faith insurance practices, this occurs when you're dealing with your own insurance company. You might be dealing with your own insurance company in a variety of ways. So, Brad, let's just lay the groundwork and foundation for what bad faith is, what it means to everybody, and how do they get involved in this?
Well, bad faith is something more than breach contract. When you're basically in the insurance context, it deals with first-party claims. First-party claim is the fact that the insurance company is dealing with its own insured. And property damage, that's pretty simple. You're dealing with your own insurance company when you have damage to your property as a result of wind, hail, fire, different kind of calamities that might happen and cause a problem to your home or the property you own. It can be your car, it can be the siding on your home, it can be fences, it can be decks, it can be any kind of property you have, and that's one type of damage. In a car accident, it deals with the bad faith of, or it deals with the contractual duty that an insurance company has to pay on the underinsured and uninsured motorist coverage portion of your policy. So it always starts with a contract between the insured and the insurance company. And when that contract gets signed and why that contract is in existence, and when claims are being made on that contract, there are certain rights that both sides have, certain duties that both sides have, and insurance companies have a duty of good faith. They have to deal with their insured under a duty of good faith, and that means they must appropriately handle your claim.
Right. You know, when you're injured in a car accident, the insurance company for the at-fault party, the one who hit you and injured you, basically doesn't owe you any duties or obligations, none. But when you're dealing with your own insurance company, and you will and you do, even though you're a victim of a car crash or a truck car crash or a bicycle crash, when you deal with your own insurance company, then it becomes important to understand that your own insurance company, because they're your own insurance company, has certain duties and obligations to you. And we're going to cover some of those today. But when they breach those duties, it's called bad faith. And yes, you can maintain an action against your own insurance company. They happen every day in this state, all over the country. Insurance companies engaged in bad faith insurance practices. You know, Brad, basically we had the common law bad faith to begin with. Now we got some statutes in Colorado that don't replace or eliminate the common law, but add to it. But, the basic premise, and there's lots of ins and outs to this, the basic premise is the insurance companies have to treat their insured, you, in this example as an injured victim, in good faith, not in bad faith, but in good faith. So basically, as a general approach, what does that mean? How do people understand that?
Well, it starts with, we've had a number of things that address bad faith. It starts with common law. We used to have common law bad faith, and we've talked about common law before in these programs. We can continue to talk about common law, but really this is law that is not statute. It hasn't been passed by legislators. It's been developed by the courts. It's what comes from a lot of times from our the basis of our law and the history of our law and how it's developed. It used to be that you had first of all a breach contract claim, but that's pretty common or pretty understandable, and it makes sense. If the insurance company isn't paying you what you're entitled to under your UIM coverage, you're underinsured or uninsured motorist, or under your property damage, you have a right to sue them for breach of contract. But the question is did the insurance company act in bad faith? And as I said, the courts have found, and everybody's determined, that when you're making a claim for underinsured motorist, you're really in a situation where you're at an unequal bargaining power. The insurance company has you at your weakest situation. You've got damage to your property. You've got damage to your own person. You're in a loss situation. You're trying to make up for that loss situation, and you think you've paid for coverage for that. You think you've paid for a way to make sure that loss that you've incurred is not going to be crippling. You hope you're going to be able to get some recovery. So the insurance company starts out having the upper hand. And so, in common law, the question was always whether or not the delay or denial of your claim or the unreasonable adjustment of your claim was what were they called fairly debatable. And that was the term that was used in common law all the time. Is it fairly debatable? Insurance companies had a broad scope on that and used fairly debatable quite a bit. It took court cases, and it took going to the Supreme Court and a number of different fights to have the courts realize, or to have the insurance companies start to come to their senses a little bit on the fact that, not everything is fairly debatable. Because if the insurance company had its way and its defense lawyers had their way, every single question would be fairly debatable, and they'd avoid the bad faith.
Therefore, they'd not be responsible for anything.
And in common law, if the claim was not fairly debatable, or the denial or delay was not fairly debatable, then the insurance company was subject to punitive damages, and that had to be determined by a court of law or by a jury.
Let's give a couple of examples. So let's say you have hail damage to your house, and you put in a claim with your insurance company, and they say, we're not going to pay you anything. And your hail damage, let's say, is $12,000. And they say, we're not going to pay you. And you say, why? And they say, is it covered? Am I covered? Is there some exclusion? Why are you saying you're not going to pay me anything? And so let's assume, for this example, you had hail damage, $12,000, and it is covered, specifically covered. No argument about coverage. That's a pretty clear example. We're just not going to pay you. We don't want to pay you. Don't call us anymore. That's an example, a clear example of bad faith. It gets a little bit more progressive as you go through the examples. Another one, Brad, is if you're injured in a car accident, a car crash, truck crash, and you need medical treatment. If you have MedPay with your own car insurance policy, let's say your medical bills are $10,000. Let's say you had the statutory minimum of $5,000 of MedPay, and they say, we're not going to pay any of them. We're not going to pay your medical bills. And you had to go to the emergency room, you had to go to the ambulance, you had to go to your primary care physician for follow-up, you had to go to physical therapy, and they say, we're not going to pay for any of them. So that's a clear, on the one side of the extreme example, or two examples of how bad faith really works. They're not going to pay it. It's covered. They're just not going to pay. And they don't give you a reason or basis. So that's where Brad was saying under the common law, they would say, well, it's fairly debatable, but it's not fairly debatable in that situation with regard to your medical bills or your hail damage. I don't think a lot of people understand that, Brad, this bad faith can also apply to property damage to your house, to your car, to your personal property as well.
Well, it's a major issue with property damage. The courts have really restricted the fairly debatable standard, because most attorneys, if they're going to sue under the statute and under common law. The fairly debatable standard in a case called Vaccaro versus American Family, and in that case, the court started saying, look, you can't make everything fairly debatable. So there's got to be some rhyme or reason. There's got to be some sense made to what you're doing, and that's going to be on a case-by-case basis. It makes it hard at times if you're trying to pursue the claim and claim that they're being unreasonable or they're not, or it's not fairly debatable, because the insurance company always has a defense, and now you're dealing with who's got the upper hand as far as money to advance litigation and to go into lawsuits, and who's got the time to go into it. But on a property damage, it's a situation of you get on the roof and you start saying, okay, should the roof be repaired or should it be replaced? Should the roof damage be $5,000 or should it be $80,000? Should the siding and the frames on the windows where the hail has beat the heck out of the frames and is beat on the windows, should the windows be replaced or should they just be painted? And that's where you can start arguing before the statute whether or not it was fairly debatable or whether, look, you can get 9 out of 10 contractors out here, you can get 7 out of 10 contractors out here, and they're going to say replace that. That's been beat up. That's got to be taken care of. Now, obviously, the insurance companies can always find their adjusters. They can always find their estimators who are going to be on their side and are going to, in essence, excuse my language here, folks, but they're going to screw the public and they're going to screw the consumer. They're going to screw the insured. But basically, you hope you can find, and you do find, the necessary people. Sometimes you have to go as far as getting a public adjuster, but that's what's happening in property damage.
Right. You know, sometimes they say, well, you can't sue us for bad faith. You can't claim bad faith because we hired our own appraiser, and our appraiser came in with the damage at $2,000. Your contractor, seven of them, came in with the damage to be $50,000. So we were acting in good faith because we had our own appraiser. Well, sometimes the relationship between the insurance company and the appraiser proves that situation is not conducted in good faith. In fact, it's conducted in bad faith. Okay, you're listening to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. Today we're talking about bad faith insurance practices. Today we're covering the common law. Today we're covering the statutory law in Colorado, showing you what rights and remedies you have dealing with your own insurance company, whether it's your property damage insurance company, whether it's catastrophe, whether it's a car accident, whether it's MedPay. We got more on that coming up. We got a break. You're listening to Bell and Pollock. We are your champions of the people. Good morning. Welcome back to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. Today we're talking about bad faith insurance practices. How does that impact you? What does that mean to you? Well, when you're dealing with your own insurance company on a variety of subjects, whether it's property damage, injury, payment of your medical bills, they have to deal with you in good faith, and we're breaking that down to its components today. Obviously, we can't cover every facet of this, but we can teach you and educate you with regard to this subject. Okay, so Brad, right before the break, we were talking a little bit about property damage and car insurance claims and MedPay. Let's get into, we were talking about the common law where they say it's fairly debatable, but let's get into some of these statutory remedies, which has changed the playing field a little bit more for the consumer, a little bit more for the homeowner, a little bit more for the injured victim.
Well, the statutory authority has gotten rid of or modified at least the fairly debatable issue, and it's instead talks about whether or not you're acting with a reasonable basis and whether or not the benefits have been deprived or whether they've been denied or whether they've been delayed on a reasonable basis rather than fairly debatable. And you know, once again, these are terms of art that if you have a claim, you really need to contact an attorney and talk and deal with it, because you're going to be dealing with, in the statutory concept, the statute itself identifies and specific acts which can be determined to be bad faith or can subject the insurer to penalties under the bad faith statute. Now, still, those are pretty wide open. They're pretty nebulous. They're concepts that have to be decided by, a lot of times, 6 jurors sitting there looking at it and deciding whether or not they feel it's correct or not. Just to go back for a second, you think, okay, well, you gave me property damage on how, you know, the contractor is having difference of opinions and who the contractors are, and they're using their favorite contractors, can be a question as far as a reasonable basis or even fairly debatable, but that doesn't work in personal injury. Well, it does. Anytime your insurance company tells you they want you to go to what they call an IME, and I always call those an insurance medical examination or a defense medical examination. They always like to say they're an independent medical examination. They're anything but independent. But anytime your insurer says they want you to go to an IME, the first thing you want to see is who are they picking? Because they have the right to pick a doctor that you go see to determine whether you're hurt. And once again, Are they sending you to doctors that are renowned or well known for being on the insurance side, or renowned and well known for being on the defense side, who most of the time are going to find somebody not hurt? And the question is a jury going to look and go, well, that's not really reasonable, and that's not really, fairly debatable. You sent them to your own inside straight person that you knew you had a high likelihood that they're going to find no injury or at least a very little injury. That can be a basis for bad faith. But, when we get in the statutory situation, we have specific identification of things that can happen that are considered to be bad faith unless the insurance company has really a very good reason on why they've done the acts they have.
Exactly. And we've done shows on the so-called independent medical examination by your own insurance company against you. And so you have to go to the doctor, you have to, quote, cooperate with them, you have to go to their hand-picked doctor, and guess what their opinion is, and guess what their opinions are about you, the injured victim. So that's one flavor of bad faith insurance practices in the personal injury field. Also, you have the property damage field as well, and we're trying to cover a little bit of both today. But the overriding theme of these new statutes in Colorado, Brad, is the fact that they cannot, an insurance company, your own insurance company, cannot unreasonably delay, think about that, they cannot unreasonably deny payment. So think about either delay on the one hand or deny payment. And in the examples we gave you earlier, you're injured in a car crash, your own med pay coverage from your own car insurance company says we're not going to pay any of your medical bills, and you've got $10,000 of medical bills. You had to go by ambulance. You had to go to the emergency room. You had to go to follow-up with your primary care physician, and they say we're not going to pay. So that's an unreasonable denial of benefits, an unreasonable denial. Now, let's try to give an example, Brad, of unreasonable delay, because that's the new, that's not all the parts of the statute. That's the initial triggers in the statute, but unreasonable denials are not going to pay anything, or denial might be they're not going to pay part of one claim. We'll pay half of it, but we're not going to pay the other. But they can engage in these unreasonable delay procedures as well.
Well, they can. And, first of all, they in-house, an insurance company in-house really, is required to have procedures that are to be followed in adjusting a claim. And when I say adjusting a claim, that's determining the value of your claim and dealing with your claim. They should have in-house procedures. Now, the first thing we're going to do is we're going to say, do those in-house procedures meet with insurance company standards? And if they meet with insurance company standards, within the standard that would be there of all insurance companies, then that starts the process saying, okay, now we have in-house procedures that the insurance company has determined these are the procedures and the timeliness with which the claim should be dealt. Now you start taking your particular claim and you measure what the insurance company has done in relationship to its own standards. That's a beginning point because you want to see if the insurance company has followed its own basic rules. It's supposed to have those rules. It's supposed to make sure that it has some kind of procedure to enforce a rule and to make sure that their adjusters are acting on matters timely. The question is does the insurance company, has it bothered to set up these rules? Are those rules reasonable? And now are the adjusters following those rules?
Right. And to discover, you're not going to believe this, but you have to get into an action with your own insurance company because they unreasonably deny payment or they unreasonably delay payment. Well, I'll give you a couple more examples of that in a minute. But you have to get into an action with you. You got to file a lawsuit to get your benefits because they won't pay. They said we did everything proper. You say, no, you didn't. You delayed me 6 months, a year, year and a half. You wouldn't pay me. You tried to lowball the offers to me. That's not reasonable in my situation or my circumstances. But to even in the litigation, to try to get through what's called discovery, their procedures, their rules, their protocols, to determine whether or not they met their internal rules, their internal protocols, internal guidance procedures, is sometimes borders on the unbelievable because they don't want to give them to you, because they don't want to give them to us, because, Brad, if they do, then they understand that one thing we're going to do is compare what they did on their internal procedures and rules as to how this claim was adjusted. And were there any entries that were contrary to the rules? And if so, why? And how did you deviate? And why did you deviate? But that's just one part of it. There's also the common law they have to comply with, the statutory law they have to comply with, and the rules and regulations of the insurance commissioner. But so the rules and procedures, just to get them, just to understand them, and see how they do it and how they adjust your claim is sometimes quite a procedure.
It is quite a procedure, and it once again goes to the question of whether or not you think the insurance company is acting in good faith or bad faith. Now, we do have law talking about whether or not the continuing actions of the insurance company, even after the lawsuit has been filed, can constitute a basis for or contribute to the evidence of whether or not the insurance company is acting in bad faith or good faith. And a lot of courts are reluctant to take what the attorney is doing in the zealous advocacy of their client, the insurance company, in fighting you, and say that's part of the bad faith. But on the other hand, this duty of good faith never ends. The insurance company has this duty of good faith. A lot of times now, you're looking at insurance companies and you're saying, why aren't you, if you made a mistake or if you claim you weren't acting in bad faith, when it's pointed out to you that this is a pretty obvious reason why money should be paid or there should be recovery, and you should have done it more promptly, or at least this amount should have been paid. Why didn't you pay it? The insurance companies seem to be fearful enough of the statutes. Believe me, they wouldn't do it on their own. It takes the statute. It takes courts of law. They seem to be now concerned enough that they approach the issue by trying to pay at least what they call the uncontested amount.
Right, they do, and that's the Fisher case in Colorado decided a little over a year ago, which changed the landscape of how insurance companies deal with you, and you need to have attorneys that know about that. You can call us anytime at 303-795-5900. You can also go to our website, championsofthepeople.com. It's an information-loaded website. It's there to educate you, to teach you. You can call us and ask any questions, or you can email us. The thing I want to say is one of the examples of how an insurance company can engage in bad faith with you, the insured, the victim, is they keep saying, we got to fill out this Form X, then you got to fill out Form Y. You got to fill out Form Z, and then you got to fill out Form A, and then B, and then C. And some of these forms, and a lot of times they have the same information, but they say these are required forms. And you say, well, I already answered that in Form X way back when. No, you got to fill out Form Y. So when they start inventing these procedures and overlay them and put them on one layer after another, that can constitute bad faith. That's another example to get your eyes wide open. If they don't follow their internal procedures, another example. If they don't follow the law, another example. And Brad was just exactly right on the Fisher case. They have to now. In the old days, they would say you put in a claim for hail damage. They say we're not going to pay you. We think the claim is worth $10,000, but we're not even going to pay you that till you come capitulate and come down to our numbers or close to our numbers. That was the old days. The new days now, when they come to evaluation of your claim, $10,000 in that example, they got to pay. And they got to pay right now, and that's the Fisher case.
Right. There's no reason for them not to pay it. I mean, that's been one of the big issues is, wait a minute, you hold all the money hostage when you know you owe X number of dollars for sure because you want to get a what they call global settlement. They want to get a complete resolution. And insurance companies will try to do that, and they push that on to people who don't have attorneys because people who don't have attorneys tend to just agree. They go along with it. They say that's fine. And the problem is it's not fine. And people look and say, well, I needed to get my roof fixed. I had some leaks. Or I needed to get this stuff fixed, and I wanted to get it fixed. I had contractors saying they wanted to get it done. So I went ahead and took the insurance company money because it was a take it or leave it, all or nothing. Well, it doesn't have to be that way. There's a lot of times when you just need to delve into and get the information from the insurance company as far as how they're valuing the claim. And if you ever want to watch an insurance company squirm and fight and argue
and run for cover,
ask them for their valuations or ask them for their reserves. Right. They will fight it every single step of the way to keep from telling you what they know they owe you.
That's a great point because, to evaluate your claim, they got to fill out certain paperwork, right? And they usually call it an injury evaluation form or a property valuation form. Well, ask them for it. Tell them to give it to you. How did you come to this number of X? How did you come to this number of $6,000? I want to know. And you ask them for it. They probably will tell you either you're not going to get it or they just won't answer the question. All right, you're listening to Gary Bell, Brad Pollock. Our law firm is Bell & Pollock. We are injury attorneys here to help you. We've been doing this show for years. We do other radio shows as well, all to give you information. Go to our website, championsofthepeople.com. It's an information-loaded website, all designed to help you, educate you, and teach you. We'll be right back. Good morning. Welcome back to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. Today we're talking about bad faith insurance practices. What duties and obligations does your own insurance company owe to you, and why, and what are they? So Brad, just kind of wrapping this up, you have the common law bad faith that's still available. You have statutory bad faith and several statutes in Colorado that give you remedies, but people need to understand that their insurance company owes them duties.
Oh, and that's the beginning part. You need to understand that they're not doing you a favor. When you call them up and say, I've had damage or I've been hurt and I need money and I want to make a claim on my policy, and they call you up, do not think, oh, boy, they're doing me a heck of a favor and they're taking care of me, and act like they're doing something. They're honoring a contract where you have paid money to get this coverage, to get this money. And they're doing their job. They're doing their contractual duties. They're doing their good faith duties, and hold them to that. Make them do it.
Exactly right. And so you need attorneys that understand the common law, the statutory law, and that have been through this fight before. That's Bell and Pollock. We're glad to help you. We're glad to give you a free initial consultation, and included in the free initial consultation, a free legal game plan, because the insurance companies have their own legal game plan. Period. Understand that. Know that. Okay, Gary Bell, Brad Pollock, go to our website, championsofthepeople.com, because we are your champions of the people.